very much, Kim Walter. If we can have another round of applause. Now, Merisa Bowers established her law practice in 2010, where she works to promote the value that everyone, regardless of class, gender, income, race, or age, deserves competent and compassionate legal representation, a longstanding value of her family. She is a member of the Human Rights Campaign, Equality Ohio, the National Coalition for Sexual Freedom, and the NCSF's PeopleWare Professionals Directory. She is going to speak with us today on legal issues of consensual non-monogamy and alt relationships and the interplay with morality faith-based legislating. Please welcome Merisa Bowers. Okay, can everybody hear me okay? Okay, no?
Microphone.
I hear you. It's great.
It's on.
Oh.
I can just hold it. Okay, thank you all for being here, and thank you to Monette and to the Center for Inquiry Northeast Ohio for having me. This is a new topic for me. This is first time I've presented in public about this subject, so thank you so much for having me, and bear with me, please. I'm an attorney. I am in my 4th year of practice, so I'm still a little wet behind the ears, but I'm figuring it out. I have a solo office. I practice in the areas of domestic relations and criminal defense. Recently, I have made a decision that I am going to be out in my practice as a kink-aware professional. What this means is that I represent and am open to representing people who lead consensual, non-traditional relationships. I represent LGBT members in legal issues, particularly with regard to family law or criminal issues. I also represent people who choose to practice polyamory or SM relationships. And I'll go through and define what those are and what types of legal issues they encounter. In terms of how that interplays with secularism, it's very similar to the LGBT issues that Kim was just stressing. Unlike the LGBT community, the kink and poly community is still pretty unknown. There is we do not really have a whole lot of active legislation pending. It's still in its early phases of becoming out. Many people are still in the closet when it comes to these issues. Let me explain a little bit about what polyamory is and give you some working definitions of what these terms are. And a lot of my information and a lot of my materials are from the National Coalition for Sexual Freedom. It is a national organization that is a lobbyist to state and national legislators. So polyamory is the desire for and conduct of responsible, non-monogamous, consensual, romantic relationships with more than one partner. Polyamory is different than cheating because of honest communication between partners and lovers about their relationships. Poly relationships do take many forms. They are most commonly known as open marriages, where people may have don't ask, don't tell policies in their own marriage, or they may take on different forms where they're more open, such as triads, where there would be 3 people who are intimately involved together. They may live together, they may not. Another very common form of a poly relationship would be where there would be a primary partnership, such as a husband and wife, or a gay couple or a lesbian couple, who decide to have secondary partners. They would be primarily committed to their first relationship, but then take on a secondary relationship, anywhere from an intimate friendship to something more sexual. Poly people focus on love, commitment, and family, just as monogamous people do. There have been some studies since, I have some studies dating back to the 70s, that do try to identify and address polyamorous couples. Um, in a 1980 study of over 3,500 married couples, 15 to 28% had an understanding that allows non-monogamy under some circumstances. The range varies so much, again, because like Kim said, a lot of this is self-reporting. There have also been, there's also a study in the early 80s that no significant difference was found between couples between couples and general population couples in terms of psychological assessment. There's no correlation causation between poly and immaturity, promiscuity, maladjustment, pathology, or sexual inadequacy. There's also no correlation or causation between polyamory or open relationships and marital stability. There was a 1986 study that found that similar proportions of each between the traditionally monogamous couples and non-monogamous couples, their relationships survived or didn't survive. The next area I want to address is BDSM, which has become popularized recently by 50 Shades of Grey and the 50 Shades books. SM, which stands for sadomasochism, is sensory stimulation, either physical or mental, that is interpreted as pleasure. SM is voluntary, SM is consensual, SM partners are informed, and the community operates around a mantra of safe, sane, and consensual. The National Coalition for Sexual Freedom, as I mentioned earlier, has recently begun a Consent Counts campaign to educate people and legislators that the prime ingredient in SM activity is consent. In 1990, the Kinsey Institute had a study where researchers estimated that between 5 and 10% of the U.S. population engages in diverse sexual practices for sexual pleasure on at least an occasional basis. My position, and from my understanding of the community at large, is that with the expansion of the internet since the 1990s and the availability of accessing the internet, online and in-person communities, and of course, like I mentioned, popularization in the media, that people who engage in SM activity has drastically increased from that 5 to 10%. And people also may be more willing to self-report, especially if we decrease the stigmatization of it. SM has also recently been redefined by the medical community. It is no longer considered automatically to be a mental illness. As long as a person's SM practices don't interfere with their day-to-day life, it's considered to be a healthy form of sexual expression. At this point, I do want to point out that poly are not necessarily kinky and vice versa, and that kinky engaging in SM or fetish play. Similarly, the LGBT community is not necessarily poly or kinky, and vice versa. Poly and kinky people are not necessarily LGBT. There is some overlap, some correlation, but there's no causation in that area. So now that you have maybe some working definitions of the communities that I'm talking about, and I hope I haven't made people too uncomfortable at this point, I do want to address some of the legal and policy issues faced by people who do practice alternative relationships or non-monogamy. The area that I see it most frequently in, and I think that affects more people, is in the family law arena, particularly with custody and visitation in children. And this is something that Kim addressed that is a barrier, and it is something hard to deal with. There was a legal case recently in which a young child was removed from a polyamorous household after her grandparents petitioned for custody on the grounds that the home environment was immoral according to the Bible. No evidence of child abuse or neglect was found, and mental health professionals found that the child was well adjusted, but that the child's family still had to fight a court battle in order to have her returned. Even then, the child was only returned on the grounds that one of the 3 people in this triad relationship moved out, and the court made this order. This was in 1999. In Ohio, we have what's called a best interest standard for determining how children are going to be placed following a divorce or a custody dispute. The best interest standard means that an outsider, a non-interested party, is supposed to make a determination what the best interest of the child is. These things can range from determinations about what religion the child is going to be raised in, to how the child is going to spend their time, to who's going to be the primary residential parent. Unfortunately, there's no protection here. This is another area. There's no protection for LGBT community. There's no protection for people who practice consensual non-monogamy. If a judge wants to decide that that a gay person is less moral, there is no law that prohibits that from happening. Similarly, there's no law that prohibits a determination that a consensually non-monogamous partner would be not in the best interest of the child. I hope I'm making that clear. A friend of mine recently brought up too that in the religious sector, this best interest standard is applied against people who are non-Christian. Frequently, people who practice paganism or Wiccan are denied custody of their child and maybe designated a non-residential parent in divorce situations. Other legal issues that are faced besides outside of the child custody arena would be the tax issue arena, particularly with regard to preference given to and benefits given to married couples, similarly to the LGBT community. Same with end of life and estate planning, inheritance, and access to partners in hospitals. People who have more than one spouse, well, they only are legally allowed to have one spouse, but people who have more than one primary partner, who have a multi-partner household, are going to encounter the same types of things that the LGBT community encounters with regard to denying access to hospitals or emergency calls and things like that. Now, back in 1998, the NCSF had a violence and discrimination survey. They found that a third of over 1,000 people surveyed suffered some form of discrimination or persecution. So that's a pretty high number. They were threatened with losing their job or even, like I mentioned, their children because of myths and stereotypes of SM. I have had personal experience with this in my practice, where two partners who were fighting, or two ex-partners were fighting over visitation rights of their children. Even though both had engaged in SM activity, it didn't stop her from using it against her ex-husband in a reallocation of parental rights. So these things do come up in court. It really depends on the magistrate because there is no universal attitudes that have been adopted towards this. Specifically, also within the SM community, obscenity laws are often interpreted with a religious or Judeo-Christian bias. For example, the Communications Decency Act, and I will kind of put a disclaimer on here. I have not researched the Communications Decency Act. I know it's out there. It's probably something worth looking into, but apparently my understanding of it is that it's vague and open to interpretation by prosecutors, judges, and juries who base their decisions on religiously influenced right and wrong. There's a famous line about obscenity. I'll know it when I see it. And unfortunately, like I said, without more clear secularism, without more clear separation of church and state, a lot of times obscenity is going to be interpreted as religious influence, religious bias, and dogmatic-based morals as opposed to reason-based ethics. I did want to address the consent issue again. There has been legal wrangling over the last several years as to whether consent is a defense to assault. as in consent that the person consented to sexual activity as a defense to rape. Similarly, within SM criminal prosecutions, one person could say, I consented to, or the defense would be that he consented to the assault, so therefore I was privileged to do that type of activity with her. There's a famous case out of New York, People versus Jovanovic. It's a 1999 case out of, like I said, out of the New York federal court. The court ultimately held that the trial court had misinterpreted a rape shield law. At the trial, I'll back up a little bit. Oliver Jovanovic, he was a 30-year-old man. He met a woman who was in her mid-20s on the internet. They communicated by email and set up a date. They went out to dinner, and then after that, they went back to his apartment and engaged in what he alleged was consensual SM activity. She brought charges against him and alleged that it was non-consensual, that he held her against her will, and she testified against him for 6 days. During the trial, her grandmother actually said that she was unreliable, she had made up stories, and that she wished that she would drop the case. Jovanovic was, as the defendant, he was not allowed to bring in evidence or suggest that the alleged victim, the prosecuting witness, had engaged in other types of sexual activity like this before, SM in particular. He was not allowed to argue that she consented to the abuse in quotation marks. He was convicted and sentenced to 15 years to life for kidnapping, sexual abuse, and assault. His case did go up through the appellate court, and almost 2 years later, they overturned the conviction and released him. But he spent 20 months in prison and was harmed in prison while he was incarcerated. The next issue I want to address is social stigmas of alt relationships and non-monogamy. And this, I think, plays very much into the ideas of secularism, of inquiry, of atheism and agnosticism, because these communities who have made conscious decisions to live differently than mainstream society suffer the same feelings of persecution and the labels of deviance, I think, as non-believers or rational thinkers might. Similarly to the LGBT community, and especially in previous generations, people who engage in polyamory or SM activity are often closeted, and they feel that they cannot be open about their relationships with their loved ones, about their relationship dynamic. This leads to similar psychological harm, as we've seen with people who have been closeted about their sexual orientation. Depression, anxiety, higher rates of suicide, these can all stem out of not being able to be open about your relationship status. Further, when they do come out, they feel that they need to prove their lifestyle to other people, and that if their relationship ends, oftentimes they're blamed because they lived outside of this traditional boundary. So I'm trying to wrap this up and bring this back into like what you guys are interested in doing tomorrow and what you're planning on addressing with your lawmakers. These communities aren't necessarily as visible as the LGBT community has become over the last 20 years. However, this is another area that is very similar. Morality or ethics, and I think this is important and maybe something that you want to consider or have already considered. Morality or ethics does not have to have its roots in religious dogma. Policies, statutes, and interpretations that people hold can harm people who choose to live outside of traditional boundaries of society. Today we are seeing an overwhelming interest in exploring other relationships besides traditional monogamous models. The community is seeing increased attendance at poly support groups and SM events. Religious organizations, as you are probably all well versed, are typically the last to make major changes to push against traditions. And this is something I think where we can use policy, use law to advance protections of classes that are less visible. I do have a handout with regard to guidelines for custody disputes. This has to do with people who are, I think this applies to atheists or agnostics as well as it does to people who practice alternative relationships. This gives you some ideas about what you should do in preparation if your relationship, if your primary relationship where children are involved does come to an end, how to find a lawyer, and how to be open and to talk about what's going on and what are your most vulnerable issues when it comes to a custody dispute. I did mention that most of my materials did come from the National Coalition for Sexual Freedom. A little bit about the NCSF. The NCSF is a not-for-profit organization. It was founded to defend the right of American citizens to individual autonomy and privacy in the sexual sphere. The NCSF, in serving these goals, opposes governmental regulation of adult consensual sexual interaction and discrimination based upon sexual orientation. Among the sexual practices which the NCSF seeks to protect is consensual sadomasochistic conduct which is engaged by a significant, albeit silent, community. Local resources are a group called Adventures in Sexuality, Poly Columbus, and up in Northeast Ohio, Cleveland SMART, and the Akron Purple Rose Society. And I'm more than happy to take questions. Or not.
Go ahead. No, go ahead.
I'm just curious, my son and his wife are in an open marriage. Did it start out that way, or when they started having issues in their marriage, they decided to go that route to see if they could, maintain their relationship. They've got 2 children, so rather than get a divorce, they decided to open up their marriage. And I'm just curious because both of them are practicing, that concept of, seeing other people, but yet maintaining their relationship. What issues, does it make them equal? If there is a custody issue, if there is a divorce down the road, how do you see that playing out?
Well, I'll start off by the disclaimer of every factual, situation is different, and it completely depends on, what's ultimately presented in that situation. Like I mentioned, even if both people are engaging in a particular activity, it doesn't necessarily stop them from trying to use it against each other. But it does kind of operate like the theory of mutually assured destruction. And if they both have enough sense and they're not vindictive or completely hateful people, then usually they can figure out a way to, I'm a big proponent of dissolutions, where people negotiate before they file a complaint for divorce and work out a parenting plan and work out a separation agreement in advance. It's much more cost effective as a side note, but it also stops that from coming out, at least at that stage of the game.
So you don't think it's more damaging to one partner than the other? It could be equally, it's more of an equal damage. And the reason why I ask is because, I always think, my son, or actually both of them, my daughter-in-law too, I talk to them equally especially when they're going through their issues, and I guess, that would be the signal. I never thought about the dissolution, that if they could come to an agreement, that it would be better for everyone involved to
Absolutely.
take that out.
Yeah.
The fighting.
The one factor where I have seen it make a difference is if one moves in with the other partner first and then immediately starts a relationship between the children and the new partner, that and again, this is what I mentioned, like, it varies judge to judge and magistrate to magistrate. But they tend to want you to focus on your children instead of your new relationship. And that applies to even people who were cheating or people who just have ended their marriage and have moved on to a new partner. Some courts get a little squeaked out by.
Could it affect the custody of both of them? I mean, both of them though? I mean, could the courts impose, like, could the courts look at it and say, we don't think either one of you are doing the best interest of your children and we're going to, you know, or is that less likely? I mean, I'm curious.
But
Yeah.
I can't say it's.
Just from some of the issues of what you're saying, and you know, I know a few people who are in polyamorous relationships, and these just, I'm seeing either people are being more open about it now. I don't know if it's necessarily becoming more common, but at least being more open about it. And, you know, and you do wonder, you know, how does this affect them as parents, and you know, when relationships end, there's a little bit more on the table than just.
The primary factor I think courts look at in regards to child placement or custody determinations is stability and fitness to parent. They really focus in on maintaining a stable household for the children, financially stable, educationally stable, those types of things. So I think that would be a bigger factor than whether or not they both engaged in extramarital relationships.
What was the basis for overturning that New York case you mentioned?
I believe it was the misapplication of the rape shield law. So there are rape shield laws, I think in every state. And what that means is that if a defendant is charged with rape, the defendant, as part of his defense or her defense, is prohibited from bringing up prior sexual activity of the defendant, basically, or of the prosecuting witness. So your defense can't be she's a slut, basically. And in Jovanovic, they ruled that the court misapplied the rape shield law and that he should have been allowed to present evidence that she consented to that activity. Does that make sense?
Suit that, but not bring up the prior.
That's my understanding.
Okay, that makes sense.
That's my understanding.
You've mentioned stuff about, similar to the LGBT not having the same sort of protections, especially like visitation rights and things like that for polyamorous relationships or other relationships. Is there anything in the works now for trying to change the laws to be more open to those things, or is it more right now just a rights activist kind of trying to raise awareness? I guess I'm not sure what stage we're in on.
My understanding of it is that we're in the, like you said, the more the latter than the former.
Okay.
Raising awareness about the issues, on the defensive if these issues are used against people, or actually not just used against people, but applied at a judicial level as impacting their access to their children or whatever. That's as far as I know at this point. I'm not aware of any proposed legislation or actual movements. The only other kind of movement that has sort of been hinted at and not really discussed is getting away from this definition of marriage as a religious institution and moving us into this contractual relationships that people enter with other consenting adults. There are a number of us who are in the LGBT community and all relationship community that would have liked to see in that direction, but I think more people, particularly in the LGBT community, which is a stronger community, thought that they should work within the framework of marriage instead of trying to just take out the whole institution.
Baby steps.
In a nutshell, you worded it earlier, so we wanted to express our, we state policies that do not discriminate against LGBT. Or, how you worded it nicely, in a package, it was those who consensually choose to participate in non-standard models, you give us that again? I forgot what it was. I didn't write it down.
It's on the-
Yeah, we said, yeah, non-standard, that would choose to go against the standard model
Traditional.
of,
The non-traditional.
yeah, okay.
Non-traditional monogamous model, relationship model. Would be my guess. I think Monet might be recording this.
We're good.
Any other questions?
I'm just wondering about the whole process. I actually got to spend time with an assistant to share a ground, and my experience was that basically, if you're not careful, it turns into you give your half-an-hour speech about what you think, they nod and pretend to understand, and they say, "Thank you very much. I'm going to make sure everything you said gets passed up the road," and the way to get around that would be to be a little more interested in having a discussion basis and trying to get input from them. What do you think? Is that the strategy for tomorrow, or is it?
I don't know. I don't know the answer to that question. I think there are people that are going to be talking later in the afternoon that are going to be better suited to talk specifically about how to lobby. My strategy is just to let them know where their constituents stand, and that's where the end of where I take it usually. Just because I try to get, I think that numbers. I just try to be part of that critical mass to make sure they know that their constituents care about particular issues. But as far as the strategy is, I'm not really sure. I'm sorry. That's not an area I've got a lot of experience in.
Okay.
No. So I'm sorry. I could be more help. Okay. Thank you so much.